Hello, my name is Casey Olden, and I am an attorney at the law offices of Chipman, Mizuko, Emerson, LLC in Danbury, Connecticut, practicing primarily business and corporate law. This presentation provides information about the Families First Coronavirus Response Act. The act was signed into law by President Trump on March 18th in response to the continuing coronavirus pandemic. The intent of the law is to slow the spread of the virus by giving people an incentive to stay home from work. The law mandates that qualified employees are required to receive paid time off in certain circumstances relating to COVID-19. Before we begin, let me issue a few disclaimers. This presentation is made for general informational purposes only, and nothing written or stated shall be considered legal advice, nor shall result in the creation of an attorney-client relationship. You are advised to consult with an independent attorney to consider the facts and circumstances that are unique to your particular situation. This presentation was put together as of April 1st, 2020. Subsequent statutes, regulations, or interpretations may alter the accuracy of the information provided. To begin, let's find out if the Act even applies to you. If your organization employs over 500 employees, congratulations! You do not need to watch the rest of this video. In a somewhat counterintuitive fashion, the Act only burdens small businesses. But, just to be sure, let's find out if you have over 500 employees. So who counts as an employee in determining the 500-person threshold? As you can see, here is a list of who is included and excluded. The Department of Labor has a test for who is considered a joint employee that I will not cover here, but you should research further if your organization is affiliated with another entity. Let's assume you have under 500 employees such that the Act applies to you. The Act went into effect on April 1st and remains effective until December 31st, 2020. This is important to note, as the coronavirus pandemic may slow in the coming months, but the entitlements under the Act extend to the end of the year regardless. Who is entitled to paid time off? The answer is pretty much all employees, regardless of how long they've worked for you, subject to one exception that I will discuss shortly. Employers may exempt healthcare providers, such as doctors, nurses, pharmacists, and the like, or emergency responders, such as police, firefighters, and EMTs. The policy implications here should be obvious, as we need the exempted employees on the front lines to fight the virus, but employers have the discretion to provide paid time off for public health reasons if one of these individuals represents a risk of spreading the virus further. I also want to point out that the definition of healthcare provider broadly extends to the other classes of people listed on the slide. The next three slides are probably the most important ones of the presentation, as they describe the details of paid leave under the Act. Regarding reason number 1, the quarantine or isolation order must directly prevent the employee from working, either at the employee's normal workplace or by telework. Regarding reason number 2, an employee may take leave only if a healthcare provider advises the employee to self-quarantine based on a belief that either the employee has COVID-19, the employee may have COVID-19, or the employee is particularly vulnerable to COVID-19, and the self-quarantine prevents the employee from working either at the employee's normal workplace or by telework. Regarding reason number 3, an employee may take leave if experiencing any of the following symptoms: fever, dry cough, shortness of breath, or any other COVID-19 symptom identified by the U.S. Centers for Disease Control and Prevention. Leave is limited to the time the employee is unable to work because the employee is taking affirmative steps to obtain a medical diagnosis, such as making, waiting for, or attending an appointment for a test for COVID-19. Here are some additional reasons for leave. Regarding reason number 4, individual means an employee's immediate family member, a person who regularly resides in the employee's home, or a similar person with whom the employee has a relationship that creates an expectation that the employee would care for the person if he or she were quarantined. For this purpose, individual does not include persons with whom the employee has no personal relationship. The employee's care for the individual must prevent them from working either at the employee's normal workplace or by telework. Regarding reason number 5, an employee may only take leave if no other suitable person is available to care for the son or daughter during the period of leave. This is an important qualification. For example, if another parent is already home caring for the kids, technically the employee is not entitled to leave based solely on this factor. Caring for the children must prevent the employee from working, either at the employee's normal workplace or by telework. There is a possible exemption for employers relating to this particular type of leave that I will discuss shortly. If an employee invokes qualified reason for leave number 5, they are also entitled to an additional 10 weeks of paid family medical leave for a total of 12 weeks of paid leave. The payment amounts are the same as during the first 2 weeks. To qualify for the 10 extra weeks, the employee must have been employed with the employer for the past 30 days, and, for employers already subject to the Family and Medical Leave Act, must have FMLA time remaining for the year. I will not cover the details of how the Act relates with the FMLA, but the regulations do provide several examples. At this point, I should probably pause and also explain what exactly is an employee's regular rate of pay for purposes of determining their leave payment. Under the Act, it is the employee's average rate of pay over the last 6 months. If the employee has not worked for the employer for 6 months, it is the average rate over each week the employee has worked for the employer. Thus, it is not necessarily what the employee was earning most recently before taking leave. There is a small business exemption under the Act for employers with under 50 employees, but it only applies to sick or family medical leave requested because of reason number 5 related to school closures. What is the standard for invoking the small business exemption? As you can see, it is if the leave requested would jeopardize the viability of the business as a going concern. The factors that may meet this standard are included on the slide. The Department of Labor is still issuing guidance regarding the Act, in particular this exemption, so additional information may come out in the future. The important thing for employers to remember now is to document exactly why an employee's requested leave was denied using these factors as a guide. Here are some additional employee rights under the Act. I should also mention that paid time off is a use it or lose it situation. An employer has no obligation to provide, and an employee or former employee has no right or entitlement to receive financial compensation or other reimbursement for unused leave upon the employee's termination, resignation, retirement, or any other separation from employment, or for any unused time remaining after December 31st, 2020. Any person is limited to the maximum leave provided under the Act. An employee who has taken all such leave and then changes employers is not entitled to additional paid sick leave from his or her new employer. An employee may take time off intermittently if the employer agrees, and, if reporting to a physical work site, the leave must be because of a school closure, reason number 5. For example, in such a case, the employee may take paid sick leave on Mondays, Wednesdays, and Fridays to care for the child, but work at the normal work site on Tuesdays and Thursdays. However, once an employee begins taking paid sick leave for any other reason, the employee must use the permitted days of leave consecutively until the employee no longer has a qualifying reason. This limit is imposed because if the employee is sick or possibly sick with COVID-19, or caring for an individual who is sick or possibly sick with COVID-19, the intent of the Act is to provide paid sick leave as necessary to keep the employee from spreading the virus to others. Notice that if the employee is working remotely, an intermittent schedule is permissible on whatever terms the employer and employee agree. For example, they may agree on a 90-minute increment, such that the employee could telework from 1 p.m. to 2:30 p.m., take leave from 2:30 p.m. to 4 p.m., and then return to teleworking. As an employer, a violation of the Act carries penalties under different provisions of the Fair Labor Standards Act and the FMLA. You also cannot require that an employee deplete existing paid time off instead of using the time granted under the Act. As noted earlier, only the employee can decide whether to use existing PTO to supplement payments due under the Act. You are also required to provide employees with notice of their rights under the Act. The Department of Labor has posters created for this purpose on their website. So at this point, you are probably wondering, how am I going to afford all of this? Well, the federal government plans to pay you back in the form of fully refundable tax credits. The amount you are eligible to claim includes the wages paid to an employee validly on leave under the Act, the health plan expenses paid on behalf of such employee during such period, and the employer's portion of the Medicare tax on such employee's wages. The tax credit will come in the form of an offset against the employer's quarterly obligation for Social Security taxes. The IRS website now has a detailed page up explaining how to request the tax credits and how to properly document leave taken by employees. Please consult your accountant for more details. In addition to the tax documentation you will need to keep for the IRS, you will also need to keep certain other records pursuant to the Act for 4 years, which are listed on the slide. Note that you are not permitted to request information from employees that is not authorized under the Act or by the IRS. That concludes my summary of the Families First Coronavirus Response Act. I want to reiterate what I said at the beginning of this presentation, specifically that the current situation is very dynamic and changes in the law are occurring around every corner. Hopefully this presentation provided you with some knowledge about how to proceed with your workforce moving forward in this uncertain time. Thank you.